Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
A New York fire company, right? And it involves the following allegations. And be clear, these are allegations contained in the suit. So the allegation is that in 2015, a female joined the fire department, the Harrison Fire Department, and right off the bat, a senior firefighter, and that's important for sexual harassment, especially in New York and discrimination, but a senior firefighter was pressuring the female firefighter with unwanted sexual advances. And so the senior firefighter continues the advances, but the female firefighter, new on the job, so kudos to her for having the boldness to do this. Again, assuming this is all true, she reports this continued harassment. She reports stalking and repeated following of her by the senior firefighter. And she claims that the senior firefighter used sexually demeaning explicatives to describe her in front of other firefighters, right? So harassment, embarrassment, it almost seems retaliatory if true. So she reports it. Now, she reports it, and then the police get involved because, I don't know why, frankly, but she reports it. The fire department doesn't do anything, allegedly, doesn't take any action, so she files the police report. What happens here is, if true, unbelievable. So the police chief then intervenes, and you would think would intervene on her behalf, but actually intervenes on the fire department's behalf. And the police chief pressures her, saying, we got to get rid of this, we got to deal with this. And she's ultimately pressured into resigning. However, she rescinds her resignation. And after she attempts to withdraw it, they fire her, terminate her anyway. So the DOJ gets involved with this. And this is not that common for the Department of Justice to get involved. Ultimately, the harasser, the senior firefighter, is arrested for her harassment and pleads guilty to harassment in the second degree. So the DOJ's got a pretty good case because pleas in criminal court, at least in New York State, and I imagine in many states, pleas to crimes are more than just some evidence of negligence, because the standard of proof in a criminal case is much higher than it is, right, beyond a reasonable doubt, is much higher than it is in a civil case. So the DOJ has got a pretty good set of facts it's facing, and the Harrison Fire Department is looking like they've got an uphill battle if they're gonna fight this. So she
Right,
sues and.
Yeah, a couple of things I want to interject in this one, because there's so many things that just in this one little case. One of the issues is, and I've seen this in other departments, where the department aligns behind the male who's accused of sexual harassment and goes against the female. And it seems to be a common occurrence. And some of the ones that I've got a little bit more knowledge of than others, and I don't have any knowledge about this one, inside knowledge, but some of the ones that I've been involved in, often we have a female who is viewed by the majority of firefighters as not really bringing a lot to the table in terms of competency, in terms of attitude, in terms of a lot of other aspects to it. Whereas the male that's accused is viewed as being a real asset to the department. And so the department, it's almost like group dynamics. You go back to kindergarten or nursery school and look at group dynamics about how people interact. But at any rate, the group seems to align behind the person who subconsciously brings the most to the table, and that's often not the person who's the victim of the misbehavior. And so that's one of the perspectives that I bring when I look at a case like that, and I'm saying, well, I wonder if this is really, because what else would explain why the police chief aligned with the alleged perpetrator, who, by the way, went on to become elected as fire chief. So he had to have some popularity within the organization. So that's sort of number one. Number two here is, this is a volunteer fire department, and the female was a volunteer. And there's an open question about whether or not Title VII of the Civil Rights Act of 1964 actually applies to volunteers. Title VII applies to employment discrimination. And there's a question about whether or not Title VII actually applies to volunteers. So I think that's going to be an issue. And you mentioned that the U.S. Department of Justice decided to take this case, which they don't usually do. I wonder if they feel that on the facts, this may be the case, this may be the test case that they want to send up to the Circuit Court of Appeals and maybe on to the U.S. Supreme Court. I don't know
it could be. One of the things in Westchester, and I was in this county yesterday doing work on Sunday, doing work with some departments, and, this topic obviously came up. And I won't repeat rumors because they're just rumors. But one of the things, as you know, and our listeners should know, is volunteers, right, could be deemed employees when their benefits rise to a level of more than de minimis compensation. And the Second Circuit Federal Court of Appeals, which oversees New York, has held that. In Westchester County, Westchester is one of the more affluent regions, areas of New York State, and most of the length of service award programs. Now, again, I'm making this up. I don't know if they have a length of service award program.
They do. It's in the complaint. It's kind of buried deep in the complaint, but they do.
Okay.
Yeah.
So that's an important fact. Now, what I will tell you is, in most of Westchester County, the length of service award programs are defined benefit programs versus defined contribution programs. And that's significant for this case. And it's going to matter because a defined contribution program says, listen, we're going to put in $400, $700, now up to $1,200 a month. We don't, get it doesn't matter what you get at the end. We're not promising you a benefit. And those programs generally, after, for example, my fire department, after about 20 years of service, which I have, I'll only generate about $15,000 of income, right? So it's not a significant benefit. But defined benefit programs, the average receipt after a good length of service is $100,000 or more dollars.
Wow.
So that, I have a hard time believing that a court is going to say, even though it would have required her to amass 20 years, $100,000, over 20 years, I think, and based on past Second Circuit and federal court decisions, I think they're going to say that, in fact, she does have or could have had, right, had she been allowed to continue, she could have received substantial benefits. And Westchester County has a lot of money. So this is one I agree we should be watching because it's going to deal with a broader question, as you very clearly state, of when is a volunteer an employee. And for the paid on-call states, this is a little easier, but New York is not a paid on-call state. And so they look at other benefits. So this is going to be a very, very interesting question. And the second part of that is, okay, but she hasn't received any of these benefits, right? She hasn't even amassed any time. In fact, she hasn't even vested because I don't think she was there for 5 years. That said, she could have gone under the state's sexual harassment suits, which while Governor Cuomo was in, he instituted, and our sexual harassment laws and protections in New York State exceed that of the federal government. So the fact that the DOJ got involved, I think, they'll hang on that. But
I think that's unfortunate. That's
unfortunate.
Unfortunate. I don't know what procedurally, if she can file within the same lawsuit, if she can file her own claims with her own attorney, bring in those state law, because you're right, New York has much broader protections for victims of sexual harassment. And so I've got on the screen here some additional details, and I might have misspoken. In the complaint, it says that she was a non-salaried firefighter who received remuneration, including life insurance, disability benefits, and college tuition assistance. So I thought there was LOSAP. It doesn't look like that, or at least not in the complaint anyway. The complaint hangs on life insurance, disability benefits, and college tuition assistance. I got to tell you, under just those three, I have a hard time believing that she's going to be deemed to be a volunteer or an employee. You take out the LOSAP, and there's almost nothing of value. Yeah, I left some cases for anyone out there that is concerned about this issue, certainly before we get a resolution on this case, which may be months to years. I gave you a couple of cases: Marie versus American Red Cross, 771 Fed 3rd, 344, 2014 case out of the Sixth Circuit. And the Sixth Circuit actually pointed to a very well-known case, National Mutual Insurance versus Darden, for the definition of an employee versus a volunteer. So, and that's a U.S. Supreme Court case, 503 U.S. 318, a 1992 case, that differentiates between volunteers and employees under Title VII. So interesting perspective there. But I agree, that New York case, knowing how protective New York state law is, you almost wonder whether or not this was a good choice in her interest, not the U.S. government's interest, but at least in her
and
interest.
This is never going to see court. Let's be fair. This is never going to see a day in court. You got a criminal plea to harassment and stalking and such. This is never seeing court. Anyway, okay. So, but my advice is yours to every fire department is stop it. Just don't do it. Sexual harassment is unbelievably prevalent.
And also be intellectually honest. This is the problem. And I get into with my own clients that separate personalities, separate who's of greater value, perceived value to the organization. I don't care who brings what to the table. Just take that off the table. Look at the factual allegations apart from perceived value to the organization. And if the allegations allege, in this case, sexual harassment or other wrongdoing, investigate the allegations fairly and then go wherever the facts lead you. Don't short circuit it by saying, well, she's a short timer. She's not really bringing anything to the table. He's here all the time. He gets the truck out at 2 a.m. and all those other things that we tend to take into account. You got to look at what the allegations are and respond appropriately, or you find yourself in fire law black.